Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about situations where bail can be raised or bail conditions can be imposed after a felony preliminary hearing. Okay, so first, what's a felony preliminary hearing? Well, a felony preliminary hearing is a step in the process on many felony cases where the district attorney, the prosecutor, needs to put on enough evidence to show pretty much probable cause hearing, right? That it's more likely than not that there's evidence here that you committed a felony was committed and that you committed it. Now, what happens after that preliminary hearing is the judge will say, okay, I believe there's enough evidence for charges 1, 2, and 3 to remain. I'm going to discharge the defendant to dismiss count 4. Okay, and then you're left with maybe lesser charges than what you started with. Sometimes the district attorney can add charges based on the testimony, based on the evidence that comes out at the preliminary hearing. And a lot of times, though, you're charged with 3, 4 offenses. Evidence goes forward. A judge may make a comment on the evidence or not, but those charges survive a preliminary hearing. And then what needs to happen is you then need to be rearranged. So it's sort of like a slightly different version of your first court appearance, where you're advised of the charges against you. What was a criminal complaint is now called an information. It looks pretty much exactly the same, except on the top right corner in San Diego County it says complaint. When you start, after a preliminary hearing, it'll say information. And it'll go over the charges, so you'll plead not guilty to the charges. You'll set at least 2 new court dates, probably 3. There'll be like a motions hearing and trial setting date. There'll be a readiness conference. So you have your motions date, motions cutoff date, readiness conference date, and a trial date. And then what's also important to consider, which a lot of people don't remember or don't realize or aren't advised of by their attorneys, is that technically, bail can be revisited after a preliminary hearing. And with the law, the law changing as it relates to bail over time, it's become less and less likely that monetary bail or cash bail actually would be increased after a preliminary hearing, unless there's new facts alleged or unless there's more severe or substantive evidence that comes out. But conditions of your release, where you can go, who you could be around, what you can do, for what times you can do it, that's what we're seeing more and more often. So it's important to go into an arraignment on the information after a preliminary hearing and have that conversation with your attorney about, hey, well, what likely or what possible additional sanctions or what additional conditions would be imposed on me moving forward, and be prepared for it. So your attorney's not up there fumbling around like, oh, I wasn't expecting this, right? So you want to make sure you're prepared for it as it relates to changes in bail after a felony preliminary hearing. So if you have any questions about bail in general, particularly though as it relates to on a felony case, how your conditions of bail could increase, decrease, be lowered, modified in any way after a preliminary hearing in your case or the case of a loved one, feel free to reach out to my firm. Again, law office of David P. Shapiro, located in San Diego, California, where we help good people regain control of their future when charged with a crime. 619-295-3555.